PA boss and astute lawyer ma NDC, one of the lawyers for the NDC, Edudzi Tamakloe, or Kasimbi Achre Ghana for. Why ha a kind judgment no 92 pages. Sedina Tamakloe appeal case no ko wini ewo appeals court no 3 judges no statement no. Ohunfo so be a wom. He's struggling to understand. Na be before the no mo yere de a proper biribiri. Na achi wo mo. Omo struggle to connect with the grassroots and to be beyond person who jump onto it. Edi make you omudi. Nana B ebe press conference no a. Ese hwe se mo yi tested na Tamakloe afiase de a ene chema wontumi. Ententem so ara munyini free prison. Then you know, I know Edudzi Tamakloe ebe respond, ebe reply no. Odika ko pm e was sempe from phone interview. Owie and call Good Morning Ghana Metro television program so. Then you know I said na Tamakloe. I think you'll enjoy this episode right here on Procedural show. For the first time, I think I love the angle to the Sedina Tamakloe discussion. Maybe a man for kind document in the year on betting maybe I see. But before that, you must subscribe. We are build notification icon over turning on video and drop your one. So feel free to leave your comment in the comment section. Over share link, you know. Now for fro and be a share. Lel Flower Green Clean Solution Center go so to months afro and a power number be say open clinic company. I'm a press yes you fee office or check bank institution. I'm a why come a why am there Mr. Fabadai for numbers no. Kakra bi be junior be trade money you po at the amount. Hey, you will clean put out your toe. For never to be what? Obey the clean washroom or kitchen office or how be come a bruta. You chili crying. Oh, just you for a kana oba kumasia. Just a traffic light no tire pay one side faso. I brusset us 1 2. I say oh pay one sa ebe kind. Jenny can go to Nana B. Nana B a press conference no share Ghana. Your judicial system, justice system no. As you trebi mubun tencha kakra. Na chama won to me. Say my you said na Tamakloe. After prison the chama won to me. More NPP for so demand say.
Ladies and gentlemen, permit me to draw your attention to one development so bizarre it removes any lingering doubt about what is afoot. The Chief Justice of the Republic has issued a warrant authorizing these two very justices, Justice Achibonga and Justice Kwakuvite, to sit during legal vacation, which commences tomorrow, 1st August. Think of it. All judges of the Superior Court, it is precisely the two judges before whom every politically charged prosecution of opposition figures are before. Who must, and they must not pause, they must work through. Why this indecent haste? What is the emergency? The only reasonable conclusion available to any objective observer is that this is part of the grand scheme involving the Chief Justice, the Jubilee House, and the two justices to rush justice and to convict political opponent at all cost. Justice hurried is justice buried. Trials conducted at a breakneck speed through vacations with accused persons denied a fair opportunity to prepare and present their defense are not trials at all. They are choreographed conveyor belt to a predetermined conviction. Why do we do this? Without a doubt, our democracy is under siege. The 1992 Constitution, for which so many sacrificed, is being hollowed out before our very eyes. And all well-meaning Ghanaians, irrespective of political affiliation, ethnicity, or creed, must rise to defend this. The New Patriotic Party demand the following. Since it is now abundantly clear that the Attorney General and the machinery of justice under the administration have no intention whatsoever of protecting the public purse, the Attorney General should, as a matter of consistency and fairness, immediately discontinue and discharge all appointees of the previous NPP administration currently standing trial. It cannot be the case that the law is a weapon against one side on the political divide and a shield for the other. The Attorney General must render a full public account of every case involving persons affiliated to the governing party that has been discontinued, withdrawn, or otherwise terminated since January 2025, together with the reasons thereof. The Judicial Council and the leadership of the judiciary must take urgent steps to restore public confidence in the administration of justice, which yesterday's decision has gravely undermined. Chairman Bernard Nchibo to me, the Ashanti Regional Chairman of the NPP, must be immediately acquitted and discharged and released. His conviction and the outrageous sentence of 20 years imprisonment with hard labor handed down barely 10 days ago were politically motivated and procured without sufficient evidence. A fact his lawyers have set out more than 20 grounds of appeal now pending before the Court of Appeal. A call to action. Massive protest ahead. Yes. Fellow Ghanaians, the time for silence is over. The new Patriotic Party hereby serves notice that on 6th of August, next week Thursday, 2026, in collaboration with other political parties, civil society, organizations, professional bodies, student movement, youth movement, and all well-meaning citizens, we shall embark on massive demonstration to defend our democracy. We are starting here in Accra and we'll be going to other regions as well to defend our democracy, our constitution, and the rule of law. I thank you, ladies and gentlemen of the media, for your attention.
We are pe ana Edudzi Tamakloe piem e kosi saying asem 94.7 FM me penny oni obi ebon komo ana friend phone so na he Edudzi Tamakloe say Nana B ade na wo ye no so what is we first vice chairperson of the NPP also o ka bibi na ne di babonten who say NPP for no they are struggling to connect to the grassroots enti omo ni nyina so bia enti omo no enema na NPP for ye no no enya ne nwa no Edudzi Tamakloe no enya ne nwa now no what kind document no who say the judges were right. The explanation here.
What in Samoa, because the NPP are not particularly happy about the decision of the Court of Appeal, but they think say we know a stage managed idea and a bina shadaye we be a court na echi to free Sedina Tamakloe. Mojene saying.
Yo, okay, Mimia, okay, and now you are in show, with you. So, I think, sir, you do and so I said, you, as in I who say, Adia, you subscribe it, which is the rule of law, no, and yet the rule of men, or the rule based on your wishes and aspirations. I said, you, Obi. If I wish is in Kwa, it be a me wish a bit different from yours. Yes. But because near the state of nature, and you know, you compared the friend the rule of law, and anything and there were now, obviously, Obi say Nana B or major election ahead of him, and Oshia. The Brenner would all call for no. So call for vice chair.
Yes, or call for vice chair, yes.
Which means and call for no more call for that way no omodoso pa in the moya de amano. Inchi opinioma a bit me amana looking desirable among the delegates of the NPP. But the verdict is that who beside NPP for now, Omo be brady, Omo canon say as national organizer of the party, no. Only the party, no, in a call one of the biggest electoral defeats ever. NPP Amanyaku Asafa since 1996. And you know, and no any the mirror Omo de judge no. And internet said you why is when you unfounded home measures are steady judgments in order to remain relevant. And yes, sir, Sebi, me and Nana B, or a lawyer need to say me, Unim, say, you will be Befano as lawyer and no court. No, could you ask money panana at the end of the day, a cobasio, court is all. So ni panon could fiase. Or no Nana B, or better say any panel for. Semine judgments na yanyadwi into a court of appeal. Na so court of appeal na nyame adom na court of appeal no kasi o sebio decision of the trial judge no yenene nyadwi he will take it and move on with his life because that is what is desirable. Sebe Sedi Nam Sedina Tamakloe in a judgment ekotiano and so on also exercising a right. You know, we said the fundamental principle, and then he said, appeal is by way of it's a creature of statutes.
Yes,
that's
true.
Into criminal appeal is a creature of statutes. Statute no hano Emma who can say there is a criminal conviction against you. Who can using the appropriate mode to appeal against that decision. A decision has been rendered. A year and one. Said you, your lawyer ni matnase, my share judgment no. I try to see say make me up punchy holes. Judges a judgment no man and I'm struggling. Look, from pages 1, I could do pages 94, which means who say the justices of the Court of Appeal Oma lay the law bare ma obibia na step by step Oma provided an outcome. Oma provided the factual matrices and in here almost say as far as we are concerned the judgment of the trial court must not stand. It is within the rights of Nana B or pray for first vice or vice to criticize the judgment. That is what democracy is about. But in criticizing the judgment, the issue will be say, what is the merit basis of that criticism? Is it a criticism destitute of merit? Is it a criticism founded on hallucination? Is it a criticism founded on conjecture and speculation? If it is one founded on hallucination, then with respect, that is not how we organize a society. Now, Sebio, my kind they on the Facebook page, but here snipers of way. I don't see the legal basis of my criticism. And I don't see how he tries to draw the government of President Mahama into this judgment. I'm struggling. Look, Obi, the Attorney General representing the Republic, fiercely fought this appeal. Unfortunately, the Attorney General's submission did not make way. The submissions filed by the Attorney General's office started first by saying, said he didn't even have the right to appeal. I don't know if you look at that portion of the judgment.
So, Omoma reason because
so okay. That's where I'm coming.
Okay.
They started by saying, having left the jurisdiction with the permission of the High Court,
yes,
and having failed to attend upon the court, she's denied the opportunity to appeal. Where from that novel legal proposition?
No, but the Court of Appeal corrected that. The right to appeal.
That is what I'm saying.
Yes.
Does it look like somebody that did not fight this appeal? This is somebody who even started by saying, the person didn't even have the right to appeal in the first place. Simply because, according to them, she's a fugitive from the law. Not only that, they fought every point of law raised by the appellant in this matter. But the justices of the Court of Appeal, they have been trained with the necessary skill set. Sebio ahami way menye judge da. What I say?
Yes.
The person in Casimir being so that. Aha. Nana B. If you are not public tribunal, and be that. Anna Obi.
No, not that I know of.
If you answer, I know what's not him, so if you are some more no so that.
Maybe.
Between me no. Said your skills are the judgment, no. Me ye be that. Me throughout my life, me ye prosecutor and so that. Criminal defense in my Obi, in my about 13 years of law practice here, my cases, my clients, they have been acquitted on submission of no case. My opening my defense, my clients are called imprisonment, among others.
Yes.
But overall, I have come to open there will be outcomes. Sometimes I call court, maybe court very upset. My baby, and my pay issue, no man, now calling me pressure, no kakra. It becomes so difficult about very excited. But also, the disclaimer, there's no business. I don't even know why he brought the government into this conversation.
Okay, so that was Edudzi Tamakloe on Asempa FM. We are no PM. Oh, Good Morning Ghana Metro Television. I think so. They can come Good Morning Ghana Metro Television. I saw later in the day. Obey interview with Asempa FM and Ra. Now Edudzi Tamakloe so quite advancing that argument saying about 23 minutes. At the end of CS, you know, and yeah, they been see down. Say Obi a lusu case for High Court. No, they call appeals court. Wako winning. Or say a taxi. No, they be a chese mame no. O nyina so bi na former Attorney General Godwin Edudzi Tamakloe who say 1 year in Myanmar yi. Kodekotie.
If you observed and follow the trial properly, and I'm sure we'll have the benefit, or maybe I can proceed because in the evaluation of the record, let me put this on record.
Right.
The second accused convict, Daniel Azim,
Yes.
as we speak, is on bail.
The CEO.
No, the director of operations,
Yes,
who
yes,
was tried
Chief
with
Operations Officer, yes. He's the CEO. Daniel Azim.
Yes, he is on bail, pending appeal. So you have a situation where, and guess who granted him the bail?
Oh.
The Supreme Court of Ghana. For the Supreme Court to look at an appeal on a criminal matter and proceed to grant the person bail, what it tells you is that the Supreme Court is satisfied that there is a high probability that the appeal will succeed.
Right.
As we speak, that second accused convict is on bail, pending the determination of his appeal. So when from all this talk, when from the impression being created that there's something extraordinary, your Attorney General prosecuted a bad case. He did a shoddy work. Unfortunately, the trial judge, from the judgment of the Court of Appeal, appeared to fill in the gap. I am always minded by the reason, in fact, the validatory judgment of His Lordship Justice Pegan in the case of Osei Kwejo II. He said, look, when a charge is defective, it is incurably bad. You cannot cure the defect with evidence. You can't.
Right.
And so in this trial, basically what happened was that the trial just sought to fill in the gap for the defective charge sheets.
Right.
And that is why the Court of Appeal, in its reasoning, came to the conclusion that you cannot invite an individual to respond to a charge that the particularities are extremely lacking. In any case, the Supreme Court has already decided, in the case of the Republic versus Ernest Thompson, that where the charge is defective, it will be set aside. And that is why in the Ernest Thompson case, the charges were set aside until the Attorney General went back and refiled new ones. That is good law. It's still in our laws.
Right.
What was the basis of the prosecution? First of all, that whole thing was a charade. I'll tell you. There's an auditing firm called Bafwewa and Associates. That is the auditing firm that the NPP used for 8 solid years to hound former appointees of President Mahama. I feel sad. I've watched commentaries by people associated with the NDC on this matter, and I said, look, you have no idea what this young woman had gone through. That is hounding at the highest level. What did Bafwewa and Associate do? When the NPP came to power, Nanaya Osafo at the office of the president Anes brought this man, Professor Duajiman. And basically what the Professor Duajiman committee did was to select former John Mahama appointees and do audits of all of them. So Morrison and Associates were given Ghana Gas. Bafwewa and Associate, Maslock and others. Deliberate. So it was on the basis of these audits that they now went to Yoko to proceed with the investigation against Sedi. Now read the records. I decided to bring a copy of the judgment here today.
Okay.
And for those who say optics, so keep an innocent person in custody. I wish you well. Look, if you look at the proceedings, and I want us to go to pages, do you have a copy?
Yes, I do.
Pages 74.
74.
Page 74.
Yes,
Are you there?
we're here.
This is PW7. The Yoko officer under cross-examination. This is what he says. During the investigation, you were furnished with several documents listing several towns under the sensitization program. Is that not so? Answer, that is so. Question, did the investigation by Yoko involve any attempt to speak to any of these persons listed in the several communities on the documentation furnished to Yoko? Answer, the sensitization program was organized by 85,000 participants with a budget of 1.7 million Ghana cedis. As part of the program, we do not have the contact numbers of the so-called beneficiaries of this sensitization program. If we had, at least we might have placed a call to one of them to confirm or deny indeed the program or organized or they were given 20 cedis as TNT. Now listen to the reasoning of the Court of Appeal. It said this admission is significant. It means that Yoko neither confirm nor refute the appellant assertion that the Maslow program took place in fact. It is also striking that the respondent, that the Republic, called no Maslow regional director to give evidence or be tested in cross-examination, but instead it relied on the evidence of PW6 and PW7 based on information given to them by the regional directors. PW7 testifies as follows. You have only concluded that there was no sensitization because you claim that the funds used for the exercise have not been accounted for. Is that not so? Answer, that is not so. Then question, what is the case then? During the course of our investigation, Yoko interviewed 3 regional directors of Maslow, and as part of the audit conducted by Bafwewa and Associate, they also spoke to all the regional directors and they indicated that there was no sensitization program organized. Also, even though an amount of 1.7 million was approved for the program, there is no evidence to suggest that the monies were used for the intended purpose. Now question, as we sit here, there is no means of establishing whether or not these regional officers spoke to Yoko or Bafwewa and Associate. Answer, that is not so. What information do you have beyond what you have stated in court? Answer, As part of the audit, this information I've given to the court is part of the audit report. Also, the 3 regional directors who came to Yoko gave statements. I am saying that before this court, only information is based on what you and Bafwewa have said. Answer, that is not so. Question, there is no testimony before this court by any regional officer of Maslock. I'm putting it to you. That is so, my lady. This is the kind of prosecution you conducted.
Mm-hmm. Wow.
And you want this to form the basis.
Serious. That's serious.
To put somebody in prison. Leonard, as defense attorney, would you tolerate this kind of shoddy work? The regional directors were not dead. You didn't even come to court, even with the statement they offered to Yoko, even for whatever it's worth. Because you knew that there's no way you can build a better case. That is how you operated under your 8 years rule. But even more shocking, you proceed to say that.
So the court ruled based on hearsay.
Even more damning ones are coming. Look, wow. If you look at page 81, and I invite you to look at page 81. Listen, this should never happen again. It matters not whether you are NDC or MPP. I also recall your testimony was that it was not relevant because you got to know that it was used for the purpose for which it was withdrawn. Listen to him. Let me even start from page 80.
Okay.
94 paragraph. Interestingly, upon the perusal of the record, I find that prosecution led evidence to collaborate the appellant assertion that she distributed the money to victims. PW1, and do you know who PW1
Who's
is?
PW1?
Sticker.
Oh, okay. He was then the Maslock boss.
Yes. Testified under cross-examination on 24th May 2021 as follows. You testified some days ago that the issues in respect of Jwadifo Adamfo are no more relevant. Was that your testimony? Answer, yes, my lady. Then he proceeds. I also recall your testimony was that it was not relevant because you got to know that it was used for the purpose for which it was withdrawn. Answer, yes, my lady. How did you get to know that it was used for the purpose for which it was withdrawn? It was through inquiry. Inquiry by who and to whom? By Bafwewa and Associate. That led us to that conclusion. How did you inquire from them? We inquire from both within and without. Within means after speaking to some officials of Maslock and then some officials of Jwadifo. But I cannot pinpoint which one of them. We came to the conclusion that the matter had been resolved. If it had not been resolved, we would have put forward additional documentation. Is this the testimony of yours captured in the report you tendered? Answer, no, it is not captured in the report.
Interesting.
Now listen, this admission by Sticker strikes at the very foundation of the charge of stealing against the appellant. PW1 Sticker knew that the appellant had distributed the funds to the victim. PW2 confirmed as much to him, yet the material fact found no place in the report tendered in evidence. If the funds were applied to their intended purpose, the allegation of dishonest appropriation cannot sensibly be sustained. And this is how we went about the prosecution.
Mr. It follows inexorably that the prosecution failed to prove beyond
reasonable doubt.
Reasonable doubt.
Look at another issue. Mo. They brought the director of finance of Maslock, or the head of finance, PW5. And look at what happened under
which page is this now? 90.
Page 85.
Oh, 85, still 85. Okay. So page 85. All right.
And the charge against Sedi was that she paid herself and her deputy, that's Mustafa.
Yes.
And for that matter, the judge found her guilty and convicted her as one of the counts.
Okay.
Now listen to what happened under cross-examination. You tendered Exhibit AD, AC, AB, which relates to payment of end of leave and ex gratia to A1 and her former deputy. Is that correct? Answer, that is correct. Question, the payments were processed by your office. Is that correct? Answer, very correct. Question, the processing was based on documents relating to the appointment of A1 and her former deputy. Is that correct? Answer, very correct. In processing for this payment, did you notice anything untoward? Answer, no, I did not notice anything untoward. Question, you put your signature under this payment because you did not find anything wrong with this payment. Is that correct? Answer, I authorized those payments because I did not find. This is the prosecution's own witness. Meanwhile, said he was convicted for this. Meanwhile, said he was convicted for this. I am sitting here and I'm wondering, what republic are we organizing? Mob? A senseless mob? To please a mob? Is that what it is?
Right.
But you see, now, and
I'll bring it.
Now, if the prosecution's own witness, PW5, had come to court and testified, and he said, I authorized those payments. It was not said. Meanwhile, this was enough basis to convict her. And the most shocking part, shocking, and I've seen NPP people put out there in their social media platform that, an amount of 61 million Ghana cedis was appropriated by her. Listen to what happened under cross-examination. Again, sticker.
Page.
I'm taking you there. You know, Sika came on board as one of the PW2.
Yes.
Do you know that the payment for the buses were done in 2017 and 2018?
Really?
Yes. Sedi didn't pay 1 CD. 1 CD.
The inflated price.
1 CD she never paid. It was Mr. Ofori Atta who issued the warrant for the payments. Said he was convicted for it. I mean, look, it's incredible. And if you look at the testimony of Stika under cross-examination, Stika himself admitted that when he took over as chief executive officer of Maslock, he renegotiated the contract. On the basis of that renegotiated contract, payments were made. Meanwhile, said he was convicted for causing financial loss to the state. You know, I know that as a political party like the NPP, at least you want to show that you were serious in government. I mean, that's fine. Curiously, it was under the NPP administration that the entire value for the buses were paid. And Stika, who was the first prosecution witness, when he came before the court, admitted this. So what was the basis for the conviction then? And that is what most of these NPP guys, they don't even know that the payment was authorized by Mr. Ken Ofori Atta with a warrant. So as we speak, Sedi is in a Sawan prison for payments authorized and done by Mr. Ken Ofori Atta. And you say that optics, so keep him in jail. Like the Roman Colosseum. Keep the mob happy. Let more blood be spilled. To the extent that the mob is happy, continue to do that. I have a challenge with that reasoning. I believe that no one should be convicted for an offense when it is demonstrably clear that no such evidence was led. Before I yield, let me respond quickly to something that my attention has just been drawn to. There's a leading member of the NPP called Kofi Ofosu in cancer.
He used to be the head of the NEIP.
He just posted something on Facebook claiming that there were missing pages in the records. What he didn't know.
Records filed by who? The Attorney General?
No, the records of appeal.
Oh, the records
you know,
of appeal.
usually the appeal is records, so it's in different volumes.
Right.
The Attorney General, the Republic, filed a motion for rectification of the record and required these 3 documents to be included in the records. Lawyers for Sedi opposed the application on grounds that the documents they were requesting for were documents given by the prosecution itself. And so how in God's name do you have documents and still be demanded? Okay,
so this is it.
So this is the
views of a senior lawyer. Says so he's also quoting the view of a senior lawyer. He says the procedure for pointing out incomplete record is not to be done through written submission. Written submission is read after date has been fixed for judgment.
So much of ignorance. So much of ignorance. What he didn't know was that a formal application for rectification was put before the Court of Appeal. And if you look, let me see. This is the affidavit in support. We herefore depose to this affidavit dated at the Attorney General's office 6th day of May 2026. And look at the request. Now the Court of Appeal. This is the ruling of the Court of Appeal. By court ruling. This is an application or notice by the Republic applicant for rectification of the appeals record. It has been opposed by the appellant. We have carefully considered all the processes filed. Detailed oral submissions of both counsel for the parties herein from the record of appeal. It is a fact admitted by both counsel that there are 3 documents are in volume 1 of the record. And as disclosed, the main issue is whether or not the record of appeal contains exhibits tendered as exhibit AM, AM1, AM by court. We therefore rule in the circumstance we have no legal option than to grant the application in the interest of justice and speedy trial.
Edudzi Tamakloe, MPA boss, and of course, a member of the NDC legal team. Fantastic lawyer, Abim Bruta. And I'm Otening. The program is here, and the big man himself, Nana B Ofori Atta, right here on Sokatwa Show. Most of for Steve Zandoni. Bye bye.